My name is Chuma Chinye, and I am your family lawyer. I was called to the Nigerian bar in 1988, and I have over 35 years' experience in family law practice. I've helped countless families navigate Nigeria's complex legal terrain, and I am desirous of bringing this knowledge and expertise to you free of any charges. My name is Chuma Chinye, and I am your family lawyer. I am immensely delighted to welcome you to a new episode of Your Family Lawyer, the weekly podcast that is designed to simplify otherwise strange and confusing aspects of family law and make them easy for you to comprehend and utilize. In today's episode, we begin a deep dive into an aspect of family law which many have been waiting for. We've been building the blocks up to this point, telling you about the types of marriage, what to do and what not to do if you wanted to get married, what to do with your wealth. Now, time for us to talk about how you manage that wealth, because we'll be talking to you about how you manage your family wealth whilst you're alive, so that when you kick the proverbial bucket, your family will not go cup in hand, beg for food, or into a rofo-rofo fight. It is called estate planning. And in Nigeria, estate planning involves the process of managing and distributing an individual's assets after their death or incapacitation. Because our job here is to make high-sounding legal jargons easy to comprehend, I will tell you in simple terms what some key principles and tools and instruments of estate planning in Nigeria mean. We're just going to go through them in summary form, and thereafter we'll take them one after the other and show you what they mean, their legal implications, and how they apply to your life. First, we'll tell you what a will means. A will is a legal document that outlines how an individual's assets should be distributed after their death. We'll devote an episode or two to explain what a will means and how you make a valid will and how it impacts the lives of your loved ones after you're gone. Then you may have heard, and if you've never heard, when you don't make a will, you are said to have died when you die, intestate. And so there is something called intestate succession, and it means that an individual has died without making a will. When that happens, the person is said to have died intestate, and their assets, what they left behind, will be distributed according to the intestate succession laws of their state or community. In Nigeria, the Marriage Act, the administration of estate laws of the various states, and the Sharia and customary laws govern intestate succession. High-sounding words. In simple terms, this simply means that if you die without having made a will or some other express plans for your estate, the type of marriage you had and the prevailing law in the place where you lived will determine what happens to the family and the property you have left behind. Then, as we go on, you're going to hear words like probate and administration of estate. Probate is simply the process of validating a will, an appointment of an executor to manage the estate of a deceased person. That is to say, a person who has died but made a will before he did. In Nigeria, the probate registry is usually found within the precincts of every high court, and is responsible for granting probate and administering estates in Nigeria. Then there is trust and trusteeship. A trust is a legal instrument, an arrangement whereby a person transfers his assets to another person called a trustee to manage for the benefit of a third party, usually your children, your wife, or some other persons, and they are called beneficiaries. For example, a father can create a trust by appointing a trustee to manage his assets for the benefit of his children. Trust can also be used to manage and distribute assets during an individual's lifetime or after their death. In Nigeria, the Trust Act of 1912 still governs the creation and administration of trusts. Well, of course, you know that the tax master doesn't spare you, whether you are alive or you are dead. And so tax planning is very important, but often ignored in this climate. Tax planning is an essential aspect of estate planning in Nigeria. The capital gains tax of 1990 and the value-added tax 1993 govern the taxation of assets and and estates in Nigeria, it is important to be familiar with them or to talk to lawyers who are familiar with them. There's business succession planning, and this simply means planning for the transfer of the ownership and management of your business when you are gone. It is best to plan them now when you are able, because if you die or become incapacitated due to illness or accident, you won't be in a position to manage your property, your business. So it is best to plan them ahead before such things happen. And of course, death in itself is inevitable. Now, there is also what is called elderly law or senior citizens and incapacity planning. Of course, we know what senior citizens mean. In some countries, it begins to come from 65 when you're getting old. Planning for that age and that time is important and involves the management of an individual's affairs whilst they are still alive. Just in case of incapacitation or ill health, a person can plan for his twilight years through a living trust or in concert with his lawyers, set up a transition mandate with his bank, which enables expenses to be made from that account for his health care or hospice or for his funeral. Of course, it may not be too widely known, but charitable giving and philanthropy can be important aspects of estate planning in Nigeria, because when you give gifts and donation, they can be used to transfer your assets in your lifetime. For instance, if you own properties, you can in your lifetime apportion them by way of gifts to your wife and to your children or to your siblings or to whoever you care to. Then, of course, it is important to familiarize yourself with these principles. Whilst individuals can create effective estate plans that ensure the smooth transfer of the assets and the well-being of their loved ones, it is important to note that it is not a one-time event. It is rather an ongoing and a continuing process. It evolves, bearing in mind your own financial status, the changes in your life, changes in relationships around you might require you to make changes frequently and regularly ensure that what you put in your will or the trust you created is still what you want to happen when you're gone. In subsequent episodes, we'll dig deep into how each of these tools or instruments or principles can be utilized to manage an estate or to protect one's estate. In so doing, we'll attempt to do a comprehensive analysis. That is to say, we will show you with reasons and with relevant authorities and good stories and decided cases, which of them might be more suitable for you. Of course, we must confess in advance that there are no hard and fast rules. It all depends, in most cases, on your peculiar circumstances, such as your marriage, your custom, or your religion. But before we go into these nitty-gritty, into these details of estate planning, there is a mighty Nigerian concept that must be deconstructed, demystified, and brought to where it should belong. It is the concept of next of kin. Many civil servants and employees fill forms at the point of employment, requiring them to name the next of kin. Some hospitals and other social services and organizations also require this. Many of us do not know this, but the concept of next of kin has a colonial heritage. It began with the colonial personnel who served in the colonial service of Her Majesty and were required to provide information of their nearest relatives who might be contacted if they died, for instance, in Lugard's country, meaning if they died in Nigeria. Recently, we conducted a little survey to ask this simple question: is your next of kin the person who should inherit your estate upon your demise? 26 out of the 30 persons interviewed believed that the next of kin is the person who should inherit their estate upon their demise. Such overwhelming majority polling might make you to believe that they are right. Surprise? They are wrong, very wrong, and woefully so. Because out of the 26 of them that thought that their next of kin was the rightful person to inherit their estate, 5 of them had made their wills. 15 were married under the Marriage Act without any will. 3 were Muslims married under the Sharia law, and 3 were married under traditional law and custom and did not make any will. The correct answer to this question will depend on the following. It will depend first on if you have a will. It will depend on what kind of marriage you contracted. It will also depend on the administration of estate law of the state where you live in. Of course, it might depend on the tradition and custom of your place. If you were married under traditional law and you did not make a will. But to answer this question, let us first begin by attempting to define what a next of kin is. Who is a next of kin? What is the real legal status of a next of kin? In general, a next of kin in Nigeria refers to the person who is closely related by blood or through marriage or by adoption to the person nominating the next of kin. It could also mean the person authorized to act on behalf of a deceased person, and its powers may include administering their estate and making decisions regarding their medical treatment if they are unwell, or their funeral arrangements if they have moved on. But truth be told, in Nigeria, the definition of a next of kin is not explicitly stated in a single legislation. Rather, it is inferred here and there from different legislations. As is obvious from the definition we attempted above, the next of kin can be used in three senses. Firstly, it can be used to simply refer to the nearest blood relative. Or secondly, it could mean the person who is to be notified in the case of eventualities of life, such as an accident, an emergency, or even death. In such cases, a next of kin may be required to make medical decisions, such as providing information or consent for a procedure for the person who is afflicted or incapacitated. Or thirdly, the term can be used to refer to a person nominated to administer or oversee a person's estate in his absence. For my colleagues who might be watching me, the Black's Law Dictionary defines the word next of kin as a person or persons most closely related to a descendant by blood or affinity. A person's next of kin is his closest living relative who will serve as first contact in the event of emergencies or eventualities. He is empowered to make decisions for the person in times of need or where the person is not readily available or unable to make personal decisions. In the course of preparing for this episode, I came across the work of Adesola Olarenwaju Kadiri of SPA Ajibade and Co., a Lagos firm. And we will quote copiously from the work that he did, whilst acknowledging the great work that he did there. He said that the meaning and legal implications of the word next of kin have been generally misunderstood, and there is an erroneous belief that the next of kin is automatically entitled to and or qualified to inherit from a deceased person's estate. On the contrary, he says, it is only those entitled to inherit a deceased person's estate that can validly do so. A next of kin is not one of such persons. Although where a next of kin has been expressly named by a testator is a person who makes a will. Where he has been named in that instrument or a document as a beneficiary, he has a right to inherit on personal grounds of having been named as such, not because he was named the next of kin. The question of who is entitled to inherit from a deceased estate is solely actually a question of law, which could either be under the English law, under customary law, or Islamic law, or indeed under the administration of estate law of each state or jurisdiction. Essentially, succession is regulated by law, and the mode of succession is largely dependent on two factors. Namely, in the case of intestacy, that is where the deceased made a will, or intestacy, where the deceased did not make a will, and the applicable law for the distribution of the deceased estate in either case shall be determined by the incidence of marriage of the deceased, or what is called his personal law. Now, let's put these legalese in context by answering the following questions. I think it's in doing this that we can simplify all that we have been saying and using legal language to say. First, what is the legal status of a next of kin when the deceased who nominated that person as next of kin made a will before he died? Because a will is testamentary in nature, that is, it becomes effective and operational only when the person who made it, called in law testator, dies. And it is only when that occurs that the properties of the testator can be distributed in accordance with his will. It cannot be based on whether or not someone had been named a next of kin by him before he died. The appointment of a next of kin will not operate as a substitute for the will already made. And this is because when a man has made a will, the position of next of kin has become irrelevant, absolutely irrelevant. Because in the will, provision is made for those who will execute the will. Except, of course, by coincidence or design, the person previously or person named as next of kin is the same person named as executor in the will. And in truth, for that person named as executor, as next of kin to benefit from that will, he must have been expressly named as a beneficiary by the maker of the will. Otherwise, his title is bogus and of no use in the circumstance. Next, what is the legal status of a person nominated as next of kin when the deceased who nominated that next of kin was married under the Marriage Act but died in intestate? That is, died without making a will. When a person who is subject to customary law contracts a marriage under the Marriage Act, there is a presumption that the Marriage Act shall regulate the succession of his estate. When he dies without making a will, essentially, the deceased person who contracted a marriage under the Act ceases to be bound by customary law when it comes to the distribution of his estate after his death, unless he made a will. Therefore, customary law will not be applicable to his estate. His estate will be distributed according to what we call English law, or the applicable administration of estate law of the place where he lives. And this is irrespective of whether or not he named anybody as next of kin. If he named anybody next of kin, it is of no consequence. It is the provision in the administration of estate law, which usually will list the spouse, the children, and so on and so forth as the beneficiary. Next, what is the legal status of a nominated next of kin when the deceased who nominated that next of kin was a Muslim and married under Sharia law but died without making a will? If the marriage of the deceased was contracted under Islamic law, the Islamic laws and the practices applicable to the distribution of property will be applicable to the deceased estate under Islamic law, irrespective of whoever he might have named as next of kin. Islamic law does not allow a person who didn't make a will to dispose of his properties just the way he likes by just naming a next of kin. The properties must be distributed strictly in accordance with Islamic law. Lastly, let's look at what happens when the legal status, when a person nominated a next of kin and then he married under traditional law and custom and died without making a will. Without a doubt, clearly, it is a customary law of that person that will be applicable to the distribution of his estate if he died without making a will. A deceased person, that is a person who dies, cannot, whilst he's alive, confer inheritance rights on persons not so entitled under customary law by choosing and naming that person as the next of kin. Under customary law, you cannot choose your heirs under the pretext of next of kin. It is the law that imposes your heirs upon you. And if you wish to avoid this, you simply make a will or alter your marital status by marrying under the Marriage Act. In concluding this discourse, we'll rely on the very good work of Davidson Iriekwe, who attempted to explain the common mistakes Nigerians make in understanding the status of a next of kin. He told the story, which I will retell here, of Funke Daudu, not the real names, who had been living in delusion. For over 8 years, she had watched her brother, Pusho Daudu, sign documents many times with her name as his next of kin. Mr. Daudu was not in a hurry to get married and had accumulated significant wealth. And the sister was sure that the brother was very rich and that if anything untoward were to happen to him, she would be the beneficiary of his properties, since it was just the two of them that their parents had, and he had persistently named her as his next of kin. Even when Mr. Daudu later got married and had 2 children, most of these documents still bore his sister's, Funke's, name as his next of kin. Then tragedy struck. One evening after returning from work, Daudu slumped, and before they could get him to the hospital, he died. The family was thrown into mourning, including the sister, the wife, and the kids. Because of the peculiar circumstances of his death, an autopsy was conducted, which proved that he died of natural causes. In fact, he died of acute hypertension. And this occurs when your blood pressure is unmonitored and continues to rise from healthy levels. Apparently, despite his wealth, Mr. Daudu hadn't been paying too much attention to his health. 2 months after Mr. Daudu passed on, two gentlemen from a reputable law firm suddenly showed up at his home with the copies of a will signed and duly registered in the probate registry. Surprise, surprise, he didn't will a dime to his sister. Nothing was given to his sister Funke in his will. You can imagine her discomfiture. You can imagine how disappointed she felt. But that's the law. And Funke Daudu is not the only Nigerian living with such delusion. With a snap of the fingers, the majority of Nigerians know whose names to write as their next of kin. They don't even have to think about it. Usually it's my wife, Mrs. Somebody, or my sister or my brother. And they're always happy each time they find that their names have been put in as next of kin. But the purpose this serves actually is just supplying information to financial institutions, for travel documents and for hospitals, and for employment. But as we readily make these choices, we often feel that the persons who have named as next of kin would naturally benefit from our wealth or assets or entitlements in the event of our demise. But please note, you should answer this question properly. Do you think that by merely picking somebody as your next of kin, you have made that person the beneficiary of your wealth? I think we provided you the answers in the course of this discourse. We may rewind and take a look at what we have said, but the answer is no. No. The answer is simply no. Well, the next of kin is actually a glorified errand boy. At best, he can be contacted or notified of something happening to the person who nominated him. He can be asked to provide information about a deceased person, but it's not for him to inherit anything. Generally, the question as to who should inherit an estate after the demise of its owner is determined by law. It could be customary law, it could be Islamic law, or what we call English law, which is the administration of estates law of where you live. And in truth, the law to be applicable in distributing the estate of a deceased person is determined by the incidence of his marriage. It follows, therefore, that where a deceased contracted a marriage under the Marriage Act, customary law is excluded. When you marry simply under customary law, well, English law is excluded. Where you marry under customary law and you didn't make a will, English law is excluded. Your customary law that will apply. And of course, if you're a Muslim married under Islamic law and you don't make a will, Islamic law will apply. Because this podcast is a legal podcast, it is one related to law. We'll not just leave you with that story. I'll just quickly give you the summary of a matter that occurred in Calabar. A certain Chief Orok died, and before he died, he had taken a loan from a mortgage bank. His son, a legal practitioner whom I know, Chief Orok Inang Ayomba, went to court, and then as he said, he was either next of kin or administrator of the estate of his father. And he said that he had paid the bank all the money that his father owed, but the bank was persistent on selling his father's property. And so he approached the court and said, please, protect this property, stop them from selling it, pending when I get letters of administration. He lost the case at the High Court, he lost at the Court of Appeal. When he got to the Supreme Court said, look, we'll ignore the technicalities of how you approach the court, because the bank said it didn't have local standing to sue as next of kin or as administrator without letters of administration. So but the Supreme Court said, no, you are wrong. You could come to court as your father's son and say, I am next of kin, that is nearest in blood, and I want to protect my father's property, pending when we determine the issue of who should inherit. That's a good purpose for next of kin to serve. And I thought we should bring you this case so that you know truly that we're not saying that there are no purposes for the next of kin to serve. There are purposes that it serves, but it is not for the purpose of inheritance. You could protect an estate if you are named as next of kin, just as Chief Oroginang Ayomba did for his father's estate, pending the approval of letters of administration. Well, that has been it for today's episode of Your Family Lawyer. We've taken time to put this in perspective because of the next things we are going to be discussing. We're going to be talking about when you make a will, why you should make a will, who should make a will, and what are the consequences, the next episode. Please join us then. But until then, Please stay informed and be protected. By all means, be good to your family. My name is Chu Machini, and I am your family lawyer.